The concept of a jury, as known in modern Western legal systems, had a distinctive development in ancient Rome. Unlike the permanent professional juries familiar today, Roman juries, referred to as judices, operated within a complex legal framework that evolved significantly from the early Republic to the late Empire. Their role was crucial in shaping Roman criminal and civil adjudication, blending legal expertise, civic duty, and political influence. Star 1. Early Roman Judicature. In the earliest Roman period, legal disputes were primarily adjudicated by magistrates or elected officials rather than by a collective body of citizens. The 12 Tables, 451 to 450 BCE, formalized certain legal procedures, but they did not introduce a jury system comparable to modern norms. Instead, private parties often sought justice through magistrates, such as the praetor, who would appoint an individual or panel, iudex, to assess the case. The iudex in the early republic was a single citizen, usually chosen from among the ranks of adult male Roman citizens. This individual acted as both fact finder and decision maker. Civil disputes, particularly those involving property or contractual obligations, were typically handled in this manner. The iudex's role was both legal and social, reflecting Roman reliance on personal reputation and public trust rather than strictly formalized legal training. 2. Introduction of the jury in criminal trials. The Roman criminal jury system, or quaestiones perpetuae, emerged during the late Republic, around 149 BCE. This development represented a significant evolution in Roman justice. Before this, criminal prosecutions were largely private affairs. The accuser initiated the process, and punishment depended on the magistrate's discretion. The quaestiones perpetuae were permanent courts established to handle specific categories of crime, such as bribery, ambitus, extortion, repetundi, and treason, maestas. Each court was presided over by a magistrate, often a praetor, and employed a panel of iudices, serving functions analogous to jurors. These panels typically consisted of Roman citizens chosen from designated classes, and the number could vary depending on the crime's seriousness and political implications. The Lex Calpurnia, 149 BCE, the Lex Sicilia, 23 BCE, and the Lex Servilia, after 106 BCE, are key examples of legislative efforts to regulate juror selection and judicial procedures. The introduction of senatorial, equites, equestrian, and sometimes mixed panels reflected the Roman attempt to balance political factions and reduce corruption. Political influence was a constant concern. Jurors often belonged to social classes with vested interests, and bribery remained a pervasive issue. Composition and selection of Roman juries. Initially, Roman juries were drawn exclusively from the senatorial class. However, growing complaints about corruption led to reforms that expanded eligibility to the equestrian class. By the late Republic, juries were often composed entirely of equites, with senators excluded from certain trials. This reform, formalized under the Lex Servilia, aimed to curb the excessive influence of senators over judicial outcomes, particularly in cases of extortion involving provincial governors. The jurors' selection was a politically sensitive process. They were generally chosen by lot from a list of eligible citizens, emphasizing randomness to limit manipulation. However, social rank, wealth, and political allegiance continued to influence selection. Jurors were expected to assess evidence, hear witnesses, and deliberate on both facts and legal principles. Roman juries did not issue verdicts in the modern sense of guilty or not guilty. Instead, they delivered a formulaic vote, which the presiding magistrate could sometimes influence or formalize into judgment. Dar 4. Function and authority. Roman juries served primarily in criminal trials, although they occasionally acted in civil matters of public concern. Their functions included assessment of evidence. Jurors evaluated witness testimony, documentary evidence, and sometimes torture-derived confessions. Application of legal principles. While magistrates provided instructions and outlined legal standards, jurors interpreted facts in light of these guidelines. Sentencing recommendations. In some cases, juries influenced penalties, particularly fines or exile, but capital punishment decisions often remained under magistrates' discretion. Roman juries wielded considerable power, particularly in politically charged cases. For example, during the late Republic, trials for corruption, provincial extortion, could end careers or remove powerful officials. The jury's composition and impartiality were therefore matters of intense political negotiation and legislative reform. 5. Reforms and imperial changes. The structure and role of juries continued to evolve into the imperial period. Augustus implemented significant reforms, including the Lex Julia de Repetundis, which reorganized jury pools and restricted eligibility to reduce corruption and enhance public confidence. Under the Empire, the senatorial and equestrian classes often alternated or shared jury responsibilities, maintaining a balance of power. Emperors increasingly centralized judicial authority, and by the late Empire, the role of ordinary juries declined. Professional judges, iudices, appointed by the emperor gradually replaced citizen panels, reflecting a shift toward bureaucratized justice. Nonetheless, the principles of civic participation and jury evaluation endured in modified forms, influencing later European legal traditions. 6. Comparisons with modern juries. Roman juries differed fundamentally from contemporary Anglo-American juries. Key distinctions include non-unanimity. Roman jurors' votes were tallied collectively, and a simple majority often sufficed. Legal guidance. Magistrates played an active role in interpreting law, whereas modern juries are generally instructed to follow the law but not to interpret it. Selection and social bias. Roman juries were confined to elite social classes, making them politically and socially partial, while modern juries strive for broader representativeness. Scope. Roman juries mostly handled criminal and politically sensitive cases, whereas modern juries adjudicate both criminal and civil disputes broadly. 7. Legacy of Roman juries. The Roman jury system laid important foundations for later European legal developments. Its emphasis on citizen participation, evaluation of evidence, and collective decision-making influenced medieval and early modern juries, particularly in Italian city-states and later in English common law. Concepts such as jury pools, randomized selection, and voting procedures reflect adaptations of Roman practices, even as the scope and democratization of juries expanded significantly. In summary, Roman juries were a dynamic institution, evolving from elite-appointed iudices to more structured panels in criminal courts. While far from modern democratic juries, they exemplified Roman ideals of civic duty, legal prudence, and the delicate balance between law and politics. Their historical trajectory demonstrates the complex interplay between legal formality, social hierarchy, and political necessity in the administration of justice. Sources: 1. Watson A., 1995, The Spirit of Roman Law, University of Georgia Press. Robinson O.F., 2007, The Criminal Law of Ancient Rome, Routledge. Trailer L.R., 1960, Roman Voting Assemblies from the Hannibalic War to the Dictatorship of Caesar, University of Michigan Press. Forborkowski A. and Duplessis P., 2005, Textbook on Roman Law, Oxford University Press. 5. Crook J.A., 1967, Law and Life of Rome, Cornell University Press. 6. Lintott A.W., 1999, The Constitution of the Roman Republic, Oxford University Press.